Mr. and Ms. Crain, it's my understanding that you requested to hold this hearing in open session. Is that correct?
Yes, sir.
I need you to confirm for the record that you understand that all open session is recorded and subject to release to any individual who requests a copy. You understand that?
Yes, sir.
Okay. Also, because you're raising concerns regarding your child's disciplinary history, the administration or trustees may address or ask questions regarding your child. That is information that would normally be discussed in closed session. Are you consenting that your child's educational information as it relates to issues raised in your complaint being disclosed in open session?
We have nothing to hide.
Very well. For the record, the Crains have confirmed that they consent for their child's educational information to be discussed in open session. While you may proceed to address your concerns in open session as they relate to your child, we cannot address other students in open session without the consent of the parent. So I'll ask that you not identify those students in your presentation. Because this is a level 3 appeal, as required by board policy FNG local, an audio recording will be made. Please avoid talking when others are speaking so the tape will accurately reflect the proceedings. I would like to note that the following board members are present. Lauren Trestle, Mike Garrett, Secretary, Ollie Lewis, Board Member, Justin Meckler, Vice President, Paul Manning, Board Member. My name is Larry Sparks, and I'm the President of the Board of Trustees. The quorum of the Board is present for this appeal. I will ask the grieving party to state your names for the record, and if you have a representative, to please identify them.
Matt Crain, I'm here on behalf of my wife Nicole and our son John W. Crain.
Thank you. Mr. Truitt, will you please identify anyone who will be presenting on the administration's behalf?
Yes, we have our Level 2 hearing officer, Amanda Adams, Assistant Superintendent, and Matt Miles, West High School Principal.
Okay, thank you very much. It is Thursday, April 9th, 2026. It is now 6:15 p.m. I will now ask whether members of this board are able to be impartial and arrive at a decision based solely upon information presented this evening or contained in the local record. If any board member is not able to be impartial, they should say so and ask to be excused. No trustee has asked to be excused from participating in this hearing. This appeal will be conducted in accordance with the district's policy FNG local in Chapter 26A of the Texas Education Code. The grievance will present a Level 3 appeal to the board. I request that the board members not interrupt during the appeal presentation. When the grievance has completed their presentation, the administration may make a reply. This is not a formal evidentiary hearing, and there will be no calling of witnesses for cross-examination. Members of the board are not to be questioned. I will ask the parties to please limit your presentation to 20 minutes each. Each party will be given an additional 5 minutes for summation and rebuttal. The timekeeper will be Mike Garrett, our secretary. Are there any questions regarding this?
I was instructed today when I got here that we have the burden of proof and therefore we have to go first. I will tell you that all previous appeal hearings that we have had, the school has gone first. So that's a new twist. I was told I do not have the ability to call witnesses or ask any questions of anybody else. So I find it kind of difficult for me to carry the burden going forward if I'm not given that opportunity. I just want that, I want you to know that for the record.
All right. Mr. and Ms. Crain, you can now present your Level 3 appeal.
Can everybody hear me okay? If at any point in time, I know they said don't interrupt me, but if at any point in time you have a question or you don't follow my argument, I need you to interrupt me. I need to know that you are not following along because I need you to understand my comments and what my argument is, okay? I'm not going to be offended at all. I'm Matt Crain. This is my wife, Nicole, and this is John W. Crain. We call him Dub. He is a junior here at West High School. Dub was involved. He plays football, basketball, baseball, track, golf. We did not let him play tennis this spring because we drew the line at 3 spring sports. But nevertheless, he's very active, very involved at West High School. On February the 20th, at a basketball practice, he was involved in an altercation with another student where they were involved in a fight. It was during the practice. They were running a drill. In between drills, they got in a fight. And I'm going to argue and ask that you watch that video when you go back to deliberate. I can't show it to you, but I know I've been told that you can watch it. I'm going to encourage you to go watch the video, okay? So pursuant to that, he was assigned or recommended placement in DAEP for 30 days. So today, Nicole, if you would, I'm going to hand you guys excerpts of the Student Code of Conduct. First one is page 21, 22. And page 21 and 22 set forth basically discretionary recommendations for DAEP. The conduct listed in 21 and 22, pages 21 and 22, they don't have to go to DAEP, but they may, okay? And those requirements and the wording that's on page 21 and 22, that is state mandated. That is copy and pasted from the state statute. So whenever you adopt that code of conduct, that has to be in there. You can't amend that. Now I'm going to hand you what is page 45 of the Student Code of Conduct. This is something that the school is added. In particular, I want you to look at number 19. And basically what it's doing, number 19 is taking a fight or an assaultive type offense, removing it from pages 21 and 22, and making it a mandatory placement in DAEP, pursuant to 19 on page 45. This is the provision that we're going to talk about today, and this is the provision that I hope that this board will amend in the future, because this is where the problem occurs. So the 3 questions that I want you to answer today, if all of you have a copy of that district complaint level 3 form, hopefully it's in your packet. And if you will go down towards the bottom of that page, I've listed 3 questions that I want you to answer. 2 of them that you will be able to answer today. The 3rd one you cannot. I'm going to pause briefly.
If you want to pause this time, or time.
If you go to the back, it's with level 3. It's on page 74. 74.
It says there's an underlying provision that says general conduct violations, and then it has the language at number 19 copied out of the Student Code of Conduct, and my 3 questions are below it. The first one says, are we ready to resume? All right. The first one says, does the above provision of the Student Code of Conduct apply to student athletes while actively participating in athletic competition? I hope that you answered that no today. The second question is, if it is yes, is the recommendation of 30 days appropriate for this infraction? So those 2 I think you can answer today. The next one, we're also asking the board to consider amending the Student Code of Conduct to create an exception going forward. And really and truly, folks, that is why I'm here today. Our goal today is to try to help this district create a better policy that's clearer, not only for the parents, not only for the student athletes, but also for the administration as well, because it has been interpreted differently as the years have gone on, and I'm going to go over that with you here now. So let's go ahead and jump into my arguments here today. Why should fights in athletics be treated differently? Well, when I say differently from a fight that happens in a hallway. So we're going to compare fights in athletics to hallway fights. That's going to be the way I'm going to phrase it. During athletic competition, I don't know if all of you have experienced it, but the easy way I can explain it is, it's just different. I know that's not very persuasive, and so let me tell you a little bit more about it. Athletic environments they have a bunch of different components in it. Your aggression, you've got coaches encouraging aggression, you've got physicality, all those are encouraged, you've got competition. And when you have all of those factors coming together in one, it creates volatility. And if you don't think that competition creates volatility, go down to the baseball park today and watch a t-ball game and observe the parents interacting. If you don't think that their interaction and their behavior is volatile because of the competition, I'm just telling you, it's special. It's a special environment. And, everybody wants to win. The kids want to win. The parents want to win. The community wants to win. Coaches want to win. We know what happens to a coach when he doesn't win. He gets fired. So coaches want to win. They want to create a competitive environment, an environment that we, at the school, is putting these kids into. It's a highly volatile environment. And, if you think that practice is different than a game, I'm telling you it is not. Practices are just as competitive and volatile as games. You go beat somebody 63-0 on Friday night, I can guarantee you practices during that week have been more competitive than that football game was on Friday night. Okay? The athletic environment also in this situation is different because you have some adult supervision there. You have coaches there, you have referees or officials there. So you have rules, and these are these safeguards that you can put on this situation to help control the volatility. So when something does happen, when the line is crossed, you have people that step in and can rectify that immediately. And that's not always the case with hallway fights, okay, or hallway violence. The other important distinction is fights that occur in athletics are generally situational. They are a part of the situation at hand. So let's say for a basketball game, the disagreement occurs over a hard foul or over a perceived cheap shot or maybe trash talking. Those are all situational, tied to the event at hand. Once the athletic event ends, the conflict usually ends. Whereas in a hallway fight, that's usually caused by more personal problems. Social media, boyfriend, girlfriend issues, bullying, things of that nature. Those tend to drag on. So there's a difference between situational conflict and personal conflict. Athletics also have recognized educational purposes. So kids go to school, and some of them probably wouldn't go to school if they didn't have athletics. They wouldn't. But athletics, they teach teamwork, they teach discipline, they teach physical development, school pride, and things of that nature. So those are good components of athletics. They are educationally recognized good things that's why we have athletics. Whereas, and I'm not saying that a fight that happens in athletics is good. That's not what I'm saying. But athletics does have some type of educational component to it. So when the fight happens in athletics, you've got to recognize that we're not only here for the athletics. There is an educational component. Whereas a fight that happens in the hallway, there is no educational component to that whatsoever. I want to read to you a text I received from Coach Allison, and I'm going to give it to you with his permission, because again, I'm not allowed to present any evidence. And I'm going to hand you that text because nobody ever interviewed Coach Allison. He was the head coach, the coach that broke up the fight, the coach that was running the practice, and nobody ever interviewed him. Okay? So this is what he has to say. I'd like a clear, defined distinction between athletic conduct and school conduct. I very well understand what culture we are trying to promote at West. However, I think it is unfair to ask athletes to never have a situation like what occurred when we as coaches are asking them to be physical and compete. Unfortunately, when athletes make contact with each other, situations can escalate. This is different than the regular school day where kids are not in that setting. And I believe that this situation should strictly be handled by the athletic department if it happens, and the punishment be given and enforced by the AD and the head coach. So how has the district handled previous incidents? And I think that how the district has handled previous incidents is a good indicator of intent. How did the district intend to apply this policy to these situations? In 2021, at the regional final football game up in Frisco, or at the Star, we played Mount Vernon. And in that game, a West football player threw a punch and was ejected from the game. Pursuant to the ejection, he was suspended. UIL suspended him for the next game or half the next game, all of that game and one of the next. He received no placement in DAEP, no ISS. It was handled by the athletic department. So I asked Dr. Truitt, I said, can you reconcile this? Can you help me understand why? In the email, please. And I got this email from Dr. Truitt, and I want to go over it with you. It says on Friday, December 3rd, 2021, during the Class 3A Regional Championship game between the Mount Vernon Tigers and West Trojans, a West Trojan football player was ejected from the game for unsportsmanlike conduct or punching another player. The player was ejected per Section 1208, the UIL Constitution and Contest Rules. The player missed the rest of the game and was ejected for the first half of the following game, which was actually the next season. Here's the important part. Both the West ISD administration and athletic department did not review the ejection for anything further than the UIL automatic penalty and report. No additional penalty or consequence was added or assigned to the ejected player per the code of conduct. I really don't know what it wasn't reviewed for means, but I will tell you what a reasonable reading implies. It implies one of two things. It implies that they didn't think that the code of conduct applied to the situation because they didn't apply it. Or they willfully disregarded it. I don't think that they willfully disregarded it. I really and truly think that nobody contemplated this scenario when that policy was adopted. I don't think that they thought that punch applied to that situation, period. And that's why we got the result we did. So let's flip the script a little bit. Let's say that whenever a student registers for school, they have to check that they acknowledge this and they've read the student code of conduct. Well, they go there, they click on it, it's a document at least 45 pages long. They say, I'm not reading all that. They close it, they check the box, and they move on. Well, now this happens, and you can say, well, I checked the box, but I didn't review that section, so therefore this shouldn't apply to me. Does that carry any weight with y'all? Because I don't think it really does. And I don't think the admin should get a pass on that either. So with that precedent set, and that it not applying to this situation in 2021, let's fast forward to 24. In the spring of 24, you have a tennis practice where two individuals get in an altercation. And in that instance, there's one of the student athletes gets a cut above his eye. I don't think it requires stitches, but neither student was given DAEP placement. Neither student was assessed ISS. It was all handled within the athletic department. And I'll say that I think the athletic department probably did a pretty good job because I'm unaware that either one of those students ever had any repeat incidents. And now we go to 2026, we have a punch thrown. There's a kid that has his eye cut, and we're in DAEP. So, I mean, Paul, you were a coach for years and years. I mean, did you ever have any student or athlete get put in DAEP for throwing a punch in a game or a practice? I mean, if you ask me and wonder why I'm a little salty at the situation, it's because of this. Because it hasn't been applied in the past, and all of a sudden it's applied now. Let's look at the punishment that was assessed. I'm going to argue that a 30-day or 20-day mandatory placement is excessive for a first-time isolated incident between two student athletes with clean records. Both of them had absolutely clean disciplinary records. The 30-day length is an arbitrary internal precedent, not a requirement in the Student Code of Conduct or state law. There is absolutely no written policy through the state or West ISD that sets forth guidelines for the length of the DAEP placement for this particular type of violation. Now, Mr. Truitt did state in an email to me that verbal discussions were had with the campus administrators regarding DAEP recommendations and the length of them. 15 days was recommended for electronic cigarettes or even vaping devices, which is actually mandated by House Bill 114. 30 days for Class 4 offenses, which is what this falls under. And repeat offenders 45 days and 60 days respectively, and 45 days for terroristic threat. I argue that the punishment assessed was excessive. And in my profession, there are ranges of punishment. If you get a Class B misdemeanor, a person is subject to 0 to 180 days in the county jail and 0 to a $2,000 fine. That defendant can serve probation. I can give them work release. They can do it on the weekends. There's opportunity. There's discretion available to me. In this situation, Dove was given 30 days. This isn't 30 calendar days. This is 30 school days. This is 6 weeks. This is 6 weeks of no classroom instruction. This is 6 weeks of missing not only games, 6 weeks of missing practices, 6 weeks of not having any social interaction with your friends or your classmates because he was criminally trespassed from the school for this period of time, and he couldn't go to the school or any school events, whether they were here or in West. So does that seem reasonable to you? Because it doesn't to me. To me, the school jumped from minimal yet effective punishment in 21 to the death penalty in 2026. But how are they different? Both incidents involved punches, both landed, one landed and one didn't. You have an injury in one, not an injury in the other. I mean, are you punishing the result or are you punishing the action? But if you allow, this is important, if you allow the athletic department to set the punishment, they have options that aren't available to campus administrators. An athletic department can suspend them from a game. They can make them do extra conditioning, bear crawls. I'm sure they can get very creative when it comes to punishment. And this type of behavior or punishment isn't available to your campus administrator for the average student. And athletic punishment can be just as effective as a deterrent as DAEP placement, and it allows the student to stay in class. It allows the student to continue to go to practice. It allows the student to continue a more normal routine while achieving the same result. Now, if the factor that you can't get over is because there was an injury, then I'm going to argue that you need to consider self-defense in this situation as a mitigating factor. And I haven't raised it before, but I have reserved it because he was not, I asked Mr. Truitt in this scenario, had the kids stopped at the push, would that have been a fight? His response was no, that would not have been a fight. So the fight then, the non-fight turned to a fight based upon the first punch. Dub did not throw the first punch. He threw the second punch. And the second punch is the punch that caused the injury, okay? There was someone that was, and it was broken up real quick thereafter. I think that if you're gonna go that route, you've gotta consider self-defense.
You got 1 minute back.
So what's the solution?
1 minute.
Thank you. The solution I am proposing to you is contained in this language that I've given to you, to add to page 45 of the Student Code of Student Conduct. And I'm going to let you read it. It's my understanding I get more time, 5 minutes as a rebuttal. But in short, you add, if a fight is determined to occur between two student athletes while engaged in athletic competition, including practices, then the athletic department will determine the appropriate discipline for the student athletes, but may refer repeat offenders to the campus administrator for DAEP recommendation. This exception for students athletes does not apply to serious bodily injury, and there's a reason for that because that opens a whole new can of worms. But I have more to say, and I will reserve that for my rebuttal.
This time.
All right, thank you. The administration may now proceed with the rebuttal.
Good evening. On Friday, March 6th, I conducted the Level 2 hearing pertaining to the matter at hand and upheld the Level 1 decision after reviewing all details. Tonight, Mr. Matt Biles will go over the details of the matter at hand. Mr. Biles?
All right, guys, my statement is just going to be kind of how we got to where we are right now. The process that I went through, investigation that I did conduct, and just kind of how we got to the level 3 hearing that we are here for today. Shortly after 8 a.m. on Friday, February 20th, Coach Woodard came to my office to inform me of 2 student athletes that were involved in a fight during a basketball practice. He also informed me of the specific time, which was around 7:42 a.m., so that I could locate the video footage and review it. Based on the video footage, I witnessed 2 students in a discussion on the baseline. It looked like the 2 students were talking through a situation that transpired in a 3-on-3 basketball drill. It seemed as though they were talking through various movements as they were seen making a blockout movement. It then looked like the discussion had ended and the 2 were going to go their separate ways. John Crain, who I will refer to as Dub from this point forward, got roughly 6 feet away from the other student, turned around and went back to engage with him. At that time, both students shoved each other simultaneously and then went into a bit of wrestling that then led into the other student swinging at Dub. Dub then swung back at the other student, landing a close fist punch to the eye. It looked as though Dub tried to swing a second time, and then it turned into a bit of wrestling again with both boys going to the ground. At that time, Coach Allison was able to get over to them and pull one of the students off. After reviewing the video, I asked Coach Woodard where the students were currently located. He informed me that one student had been taken to the clinic to receive stitches while Dub was still down in athletics. I asked Coach Woodard to send Dub to my office so I could discuss the situation with him. After my talk with Dub, he was sent to ISS while I tried to locate the other student. I was able to get in touch with the other student's mother and requested that she bring him from the clinic directly to the school so that I could discuss the situation with him as well. The other student was also sent to ISS after I had the chance to talk to him. After speaking with both students individually, I became aware of 2 interactions they were trying to talk through on the baseline. One being where an elbow was thrown to the ribs of one student and then a possible slap to the head from the other student. I was told by Dub the reason he went back to engage with this other student was due to a comment made by the other student along the lines of, "Do something about it." I believe it's also worth noting the amount of time that passed from when Dub left the 3-on-3 drill to stand on the baseline to when the students actually engaged in their simultaneous shove. Dub stopped his participation in a 3-on-3 drill almost a full minute prior to the 2 students shoving one another. I went back to view the video a few more times to determine if there was a possible self-defense clause that could be made by either student. I did not view behavior in the video that I would consider to be self-defense, so the determination was made that the fight was mutual. Once a fight is determined to be mutual or consensual, all participants involved will be assigned DAP per West ISD Code of Conduct that Mr. Crain pointed out in our Class 4 violation number 19. I've served as the campus behavior coordinator within West ISD for the past 6 years. 4 years at middle school, 2 years at the high school. In every conduct code violation I've dealt with involving a fight, the students received a minimum of 30 days of DAP. The only way the DAP length would differ from a 30-day placement is if the student's disciplinary history shows a similar previous offense. This situation would result in a longer DAP placement. This has been the standard at West ISD even before I stepped into an administrative role. In an effort to ensure 100% consistency across middle school and high school campuses, I consulted the campus behavior coordinator at the middle school to see if he had recently dealt with any fights himself. He informed me that he had dealt with one the previous year that resulted in the students receiving 30 days of DAEP. I informed the students and the parents of my recommended 30-day DAEP placement based on code and consistency. I then notified the DAEP coordinator, Diane Wilson, so she could start the process of setting up the DAEP intake hearing. I then informed the superintendent of West ISD, Mr. David Truitt. This particular scenario had 3 situations I'm required to report to the superintendent per West ISD and TEA guidelines. They are as follows. I must report any fights on campus. I must report any possible DAEP placements. I also must report any conduct that results in an injury to a child. I also notified Officer Worthy of the West ISD Police Department, and he determined any and all consequences resulting from the fight will be handled by campus administration rather than getting law enforcement involved. I was also able to touch base with Coach Johnson and Coach Allison. This is a little contrary to what we received earlier, in that I will admit I did not interview Coach Allison. But I was able to touch base with Coach Allison and Coach Johnson in the hallway just before passing period between first and second period. That means leading from athletics into second period. I simply wanted to inform them that they needed to be prepared to play the playoff game without the 2 individuals that were involved in the fight. I received a response from one coach of, "I understand." I received a second response from the other coach along the lines of, "Whatever the district policy is." It was decided the students would remain in ISS for the remainder of the day on Friday, pending the DAEP intake hearings on Monday morning. On Monday morning, at roughly 8:15, the DAEP intake hearing was held for Dub Crain. Present in the meeting were Mr. and Ms. Crain, Dub Crain, Diane Wilson, Alternative Education Coordinator, David Woodard, Athletic Director, and myself. In the DAEP intake hearing, I presented my findings as I have done for you this evening. I also willingly answered clarifying questions from Mr. Crain. In the end, Ms. Wilson upheld the recommended 30-day DAEP placement. Mr. Crain ultimately appealed the intake hearing decision, and we then moved to a level 1 grievance hearing. On February 27th at approximately 1:30, the level 1 hearing was held at the administration building. Presiding over the level 1 hearing was Ms. Carrie Cosda, West Elementary Principal. I presented my findings as I have done for you this evening, and Mr. Crain had the opportunity to present his reasoning for the appeal. After Ms. Carrie Cosda had the time to review all documentation and findings, she also upheld the recommended 30-day placement. Mr. Crain then appealed the level 1 decision, and we moved to a level 2 hearing that I was not in attendance for. Ms. Amanda Adams, West IC Assistant Superintendent, presided over the level 2 hearing and upheld the recommended 30-day DAEP placement. Mr. Crain then appealed the level 2 decision, which brings us to tonight's level 3 hearing before the board. I would agree with Mr. Crain in that the most important piece of evidence is going to be the video of the fight, which you guys need to review. I know that we're not allowed to show that in public forum, but I believe it's the most important part for the board to review the video evidence prior to making a decision on whether or not we should have essentially a separate code of conduct for athletics. Allowing such fights as this one on our campus without consequences from administration, simply because the students were involved in practice, will enable chaos and disruption to our learning environment. After the board is done reviewing the video footage, I will be sticking around as long as I possibly can to review any questions that you might have about the video footage. There are a few other things I would like to address that were brought up by Mr. Crain. He described 3 incidents: the football incident, the tennis incident, and now this one. I was not in the role I'm sitting in currently as the West High School principal when the West football incident happened. I can't speak for what did and did not happen after that student received his consequences from UIL. a suspension of 1 game. The tennis incident, as I've been told, was not a purposeful incident. The tennis incident where there was a cut on someone's eye, I was been informed that the tennis racket was actually thrown to the ground. The tennis racket bounced off the ground, hitting another student in the eye. And now we are here with this incident. Mr. Crain mentioned that he received 30 days of DAP, and that is correct. That was the initial decision. Throughout the various levels of grievances, I recommended the possibility of reduction by 1/3 for any students that receive DAP placement. And there are first-time offenders that receive DAP placement. That is based off of a model behavior agreement that was put into legislation this year. I did challenge Ms. Carrie Cosda to dig into that more. I recommend that she looked into that as that was presented to me by Ms. Crain. In the end, Dub did receive a reduction of DAP placement by 1/3, which means he served 20 days. And again, I would like to point out that he stated there would be 6 weeks of DAP. That is not what happened. There was additional concessions made. The additional concessions that were made that we would help the students out, and that would allow them to serve on Saturdays. We would allow them to serve through spring break. So it is not accurate to state that these students serve 6 weeks of DAP. It's not correct. I do want to mention clarifying piece that I requested Coach Woodard to clarify in our level 1 hearing, and that is the difference between UIL competition and practice. That kind of brings into question the West football incident. That was during a game, and that is essentially presided over by UIL. And the UIL did issue their consequence. UIL does not preside over practice. That would be the student code of conduct. Student code of conduct presides over the school, bus stops, school activities and events, whether it's on campus or off campus. The students are bound to the student code of conduct in all of those locations. Once again, I'll stick around as long as I can once you guys get done reviewing the video footage. I'm involved in a lot, not just school admin. I have a baseball game with my kids at 7:20 this evening, so I'm actually required to quit to pitch in that game. So at some point I'm going to try to get out of here, but I will remain around after you guys come from closed session to be able to answer questions if you have any questions regarding the video. At this time, I yield the remainder of time that I have remaining.
Thank you, Mr. Miles. Mr. and Ms. Crain, you now have you now present your rebuttal and summation. You have 5 minutes.
To address a couple of Mr. Biles' comments real quick. I did not say that this should not be without consequences. Athletic punishment is consequences, it's just different, okay? I did not say they shouldn't have consequences. The other thing is the model behavior agreement where the reduction occurred. We brought that to their attention. They had no idea that it even existed. And whenever I was telling you six weeks, I said the recommendation would be 6 weeks. I didn't say he served 6 weeks. That is not what I said. Finally, if he is implying that a student code of conduct does not apply to games because the UIL supersedes, that is incorrect. The student code of conduct still applies, and those consequences can still apply to a student, even if they're in games. All right, to sum it up, I am here because I want y'all to change your policy. I want you to give it to some consideration, especially going forward. So before, by the next board meeting or before you adopt the next code of conduct, please review this. these athletes need some additional protection, in my opinion. I hope you agree with that. But whatever your decision is here today, we're moving on. We're done today. We are closing this chapter today. I have no intention of going any further than today. Doug is he's back playing sports. He's playing baseball. He just finished track. He's going to compete in the regional golf tournament next week. He loves being a West Trojan. He's been a West Trojan since he was in the 4th grade. He wants to be a West Trojan next year, and we want him to be a West Trojan next year. And we are here so that future West Trojans don't get this punishment, because I don't think it was just. I don't think it was right. And I don't think your precedent from 21 and 24 say that it was your intent. Now, Mr. Ball said fights are 30 days. I don't agree with him on that. Fights are 30 days, but those are all hallway fights. Those aren't athletic fights. The precedent for athletic fights is let the athletic department handle it, which I think you should. Thank you very much for your time. I truly appreciate it. If you have any questions, I'll be happy to answer them.
Yes, I did want to talk about what Mr. Crain just spoke on. I was not trying to imply that the code of conduct does not apply to game situations. I was not trying to imply that. As I stated, the code of conduct does apply to bus stops, the school, within 300 feet of the school, or school events or activities. I know that through this process, my name has been tied to being anti-athletics. And that could not be further from the truth. To tell me that
I'm going to object if he's insinuating that I'm
not speaking on their behalf and what they believe of me. I'm talking about the public as a whole. To tell me that I'm anti-athletics is to tell me that you don't know me. Athletics has paved the way for the position I'm currently sitting at West High School. It's been a part of my life from the moment I stepped on a t-ball field, stepped on a baseball field, football field, basketball court, and on the track as a West Trojan. To the moment I stepped on the track to begin my collegiate career running for UT Arlington. Athletics continued to be a part of my life as a coach throughout the first 8 years of my educational career. I know athletics more than people think I do. I know the life lessons that can be learned throughout the years of participating in athletics. My boys are a part of West Youth Baseball, and I currently help coach both of their teams. My daughter will also become a participant in West Youth Sports because I want them to gain the valuable characteristics athletics can provide for them. My wife has spent all 19 years of her educational career coaching young women at the middle school and high school levels. She'll be the first to tell you it's not always about the wins and losses. It's about lessons learned, relationships built, development of young men and women. One of those life lessons learned through athletics is how to control oneself and be disciplined, as Mr. Crain stated. Students in athletics should be held to a higher standard to earn the privilege of wearing West on their chest in athletic competition. We should not be considering lesser standards. It is a privilege, not a right, to be a part of athletics. Creating a separate code of conduct for athletics to allow students to be held to lesser standards would create an elite group of students that would be exempt from the true student code of conduct. A student athlete is a student first and foremost. That is why athletics is considered extracurricular. Our student code of conduct is the district's response to the requirements of Chapter 37 of the Texas Education Code. The code provides methods and options for the management of student discipline in the classroom and on school grounds that once again includes bus stop, the school, 300 feet of the school, or at a school event or activity. Our current code of conduct is the standard and should remain the standard. There should not be a lesser additional standard. I yield the remaining time that I have.
All right, thank you very much. The level 3 appeal presentation is now concluded. I will now ask if board members have questions for Mr. and Ms. Crain or the administration. Any questions? It is now 6:50. There are no questions. It is now 6:58. At this time, we will adjourn to closed session. According to the Texas Government Code, Chapter 551071.
A few moments later.
It is now 7:44 p.m. Do I have a motion regarding the impeachment?
I move to affirm the level 2 decision. However, we direct the administration to report to the Board of Trustees within 60 days recommendations for amendments to the Student Code of Conduct that can include first-time offenses, administrative discretion, as well as positive behavior interventions.
Is there a second?
I'll second.
All second. Roll call vote.
Discussion?
For discussion. Is there any discussion?
I will just say I don't think I'm able to support a separate code of conduct for our athletes.
I agree. They should not be singled out as a special event.
I agree.
Or any other group. Any other questions? Comments? If there are none, then we will vote, please.
Trissel,
4.
Garrett, 4. Willis,
4.
Nickel,
4.
Lanier,
4.
Sparks.
4. Thank you very much for your time. This appeal is concluded.
I know you didn't want to be up here on Thursday night. And I appreciate it.
Is the best disinfectant. Sunlight.
Easy watchdog.
Tyranny, corruption, extortion. Sunlight is the best disinfectant.
BZ Watchdog News Network.